What's up, everybody? Welcome in. We get our first look at the new judge in the YSL trial as she lets us know what to expect. What are her rules in the courtroom? When are we going to get back to this trial? What's she going to do with all the outstanding motions? We get some scheduling discussions here. They introduce all the new lawyers to her, and we hit the ground running. We're going to let you know what we think about this judge, what our first impressions are, how we think this is going to go in the future with this trial, whether or not we think this trial is even going to continue based on what she does and did in today's hearing. Of course, I got my dad on with me as well. So make sure you guys hit the like button and we'll get into it. All right. So we had the hearing this morning. It was about an hour and a half. A big portion of it was the lawyers introducing the judge to everybody. It was a lawyers only meeting, no defendants or parties or anybody there. As far as lay people go, they were just handling scheduling. She says multiple times throughout, she's not making any substantive decisions. So no mistrial declared or even argued at this point. It was basically just get to know each other, what you can expect going forward. And was there anything as far as how the meeting or hearing was run today, Dad, that was of note to you?
Well, obviously she did a really good job. She was calm, she was relaxed, and she wanted to make sure that they knew she was in charge of the courtroom. It was her courtroom, although apparently it's the same courtroom from the way it looks. But
It has to be just because I assume they don't have that many humongous courtrooms that can seat this many people. And I think they also cleared out the gallery in the back so they could put more desks and counsel table back there.
Right. Yeah, she just wanted to show them who was in charge, what her rules were. But during the course of this, it's also important to know she's really playing catch up and how she's trying to catch up and what's going on. So we'll hear it as we're going on now.
Yeah. And I mean, I definitely think she's very competent and confident, and she's got a kind of a good personality, kind of a nice disposition, kind of a chipper personality, I think. A nice Southern drawl, which I think is going to add some, maybe a smile to this case when you look at it, as opposed to the misery and the scowl that I feel like we were feeling before when we came in and watched every part of this trial. She does not seem as exhausted and exacerbated because she hasn't been dealing with this trial for months. But there's so much going on. And we've pulled a few clips to kind of give you guys an idea of what this is like for a judge being thrown into this mess and what it's going to look like going forward. So let's take a listen to our first clip.
It determined that the judge should have been disqualified to act in the case. All proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes.
Was there a written order?
He did file a written order.
So we watched this together where he read his findings, his reasonings, his defense, basically, which was one of the reasons he was recused based on the other judge's reasoning. She hasn't read it yet. I found that kind of interesting, that maybe she hasn't done much investigating at this point on YouTube. She talks later about how the court reporter is going to type all this up, but I found that kind of interesting that she's not even that caught up in the case at this point with such a big decision that was made.
June the 14th.
Okay.
2 days later.
All right.
And that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the list. But I appreciate that. Thank you.
Can I add one other thing just for your knowledge? But
Sure.
if it's something that's more than a status, then I will withdraw it.
Yeah, I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
She's not going to make any major decisions at this point in the trial without the defendants in the room.
Understood. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away, and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name is Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the motions.
Great.
Right. What happened here was the judge had asked everybody, okay, give me a list of everything that's pending. And what Steele said was, there's one thing, we haven't filed a written motion on this, but what is an issue, and we will be filing a written motion, we want the court to know about this, is the case law is everything from the date the original recusal motion was filed and denied, everything after that is null and void in the trial. So an additional complication is the jury heard Copeland's testimony after that. So he is saying we've got to get Copeland's testimony after that out of the jury's mind. He's in, so he's talking about you got to take the jury notes away.
He's literally, sorry, I just clicked the video because I was trying to pause you from talking. That's hilarious. I wanted to respond to what you said. So you're saying that basically at this point, he's saying we have to pretend like that stuff didn't happen. We've got to get rid of the jury notes. We've got to get rid of the testimony. But then again, this brings up another question that everybody in the chat has. What do you tell the jury? Because the judge screwed up and was recused, stuff that happened over those days when he screwed up, we've got to redo because they're going to redo all that testimony.
Well, and she is saying that, this jury is still going to be gone for a week or two. So we've got to get all these issues out of the way. And that's why Steele raised it is, I don't think Steele knows how you're going to erase it from the minds of that jury. So the judge has to figure out a way, and they've got to fashion some kind of an instruction, because you're right. You're going to tell the jury, look, forget about Copeland's 3 days worth of testimony. Give us your notes of Copeland's 3 days worth of testimony. And then here's why. And the why is going to be a really interesting explanation if it comes to that. And I've got a feeling these lawyers want it to come to that.
Yeah, and that's the point is at this point, the defense has some momentum. As much as they can muck it up, they're going to muck it up, and they're going to make it difficult. They're going to make this jury know this is totally screwed up because they're talking about the investigation. They're talking about how this is all unfair. They're talking about how much pressure is being put on the witnesses. They've already gotten a lot of that out. This is all just going to go right in line with the defense's theory and what they're going to try to argue. So telling them to throw away their notes and redoing things and just talking about how this is not how it's supposed to be when you convict somebody beyond a reasonable doubt. This is just not how it's supposed to be. That's what they're going to argue.
Right. So that's why I thought that clip was an important clip, because it shows the theory, at least the beginning of the theory of the defense, of how they're going to handle this recusal and what they're going to do with Copeland.
Mildred said, finally getting to see you live and not on replay. Thanks for all you do. Mildred, welcome to the live stream. Ashley said she insinuated the DA to offer a plea deal. It seems as though if she grants a mistrial with prejudice, she doesn't want to. So actually, I want to put this comment up because we'll remember it, and let's talk about it when we hear later when she says something about maybe you guys should talk. Maybe you should talk about some kind of plea deal. I think she is in the best. I think she is the best defendants could have gotten. She has more knowledge, in my opinion, based on appellate experience. I have faith her rulings will be fair. I certainly hope so.
Let me tell you the interesting fact about this judge.
Okay.
And it's something I found in the research. If you remember, of course, Fannie Willis is the state attorney for Fulton County, where this is happening. The governor passed a bill through the legislature that allows them to remove a state attorney like Fannie Willis after a commission review of Fannie Willis. That's a new or recently passed bill. 8 state attorneys filed a motion to enjoin the governor from enforcing that bill, basically to stop the governor from doing anything under that bill. The judge who denied the state attorney's motions and allowed the governor to do what he's going to do is this judge.
So maybe already some prickles between her and the state attorney's office.
Right.
Interesting. And we know this is on random selection.
Yes.
Right? She's actually the second replacement. So it's just interesting how stuff works out sometimes. Francis said, dumb question. How many juries are there? There's just one jury deciding this, right? That
Right.
I'm aware of. Okay. This is the next clip here we're going to play.
That I can say to these other judges, I am on trial. I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on trial. Can we get that protection from the court?
Yes, you shouldn't even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes, to the extent that any judge calls at my chambers, yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So if we decide we're taking a 2-week vacation in August, which we won't be, but hypothetically speaking, and y'all aren't in here with me litigating something, then I'm probably going to say you're available, not for a trial, but for, a 1-day hearing or something.
Yes. I don't mind the one-day hearing. I do mind going to trial when
Sure.
I'm on trial.
Yes.
So with that,
Y'all are all protected from being expected to be in trial anywhere else until the end completion, however it completes of this trial.
Thank
Yes.
The end completion, however this completes in this trial.
Yeah. But interesting to note, though, that he is looking for protection for this from other courts. And, I'm wondering what these defense lawyers are thinking. I mean, those are like little hints that these guys think this trial is going to go forward and going to continue on. And this judge thinks this trial is going to go forward and continue on.
So that's the vibe I got throughout the entire hearing. Is that what you're saying too? You got
Yes.
the vibe that this is going forward. It's not going to be ended in a mistrial.
Yes.
I don't think she knows everything yet. I think she's kind of made that clear with how she's waiting for the transcript. She doesn't know about written orders. She doesn't know about, certain things that have already happened. So that could make her change her mind. But I think as we sit here today, right now, everybody in that courtroom pretty much expects this trial is going to keep going. I love the comments. Let Papa T speak. Peter, don't mute your dad. I wasn't trying to mute him. I was saying I'm so used to listening to a video and responding to the video that I was going to hit pause. Trust me, he says everything he wants to say. Okay,
I do.
Do you think the jurors will look up Glanville's exit?
I would like to think they aren't going to, but it's just hard to believe that 12 jurors or somebody's not going to look this up.
Asia said Law and Crime Chat was going at this judge for laughing. I don't understand why they were so pressed about it. First off, no jury in the courtroom, no criminal defendants in the courtroom. I think this is her job. She should take it as her job. She shouldn't have a vested interest in who wins or loses this case. She's making calls on balls and strikes. Doesn't bother me one bit that she had a more positive or friendly attitude from the bench. And I think usually that gets the job done.
No, I think her demeanor was excellent. Yeah.
I agree. Yeah. I literally couldn't agree more. I would enjoy trying a case in front of her. All right, let's go to the next clip here.
And we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well. Thank you.
And some of her giggles like that, it's like, this is unreal. And the amount of rulings and the amount of motions, some that have been reduced to writing, some that haven't. And if they haven't, how the heck is she supposed to know? And so they're going to create a little chart so she can know what happened and try to play catch up and keep it all straight, because she's going to have to. This is not how it's supposed to work in a trial.
I mean, this
Of course.
is, I'm sorry, go ahead.
No, you're good.
I say, this is like a once in a lifetime trial. This is the longest trial that's ever been in that county. This is the most bizarre happening in the middle of a 6-month trial. In this entire judicial career of this judge, this will probably never happen again. So she's, plowing new ground here in order to get all this stuff done. She needs all the help she can get to keep track of all these orders and motions and what's happened in the past.
Exactly. Bella, the plan is to do kind of a preview on that case on Monday. So if you guys are interested in the Florida v. Benfield, or however you say the last name, the Black Swan ballerina case here in Florida, make sure you subscribe and hit the reminder bell, and make sure you show up for that first video. And if you guys are interested and you guys want that content and have the questions, we will follow it. If not, we'll pick a different topic. All right, let's keep listening here.
And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just ordered that each of us present to the other the exhibit list that we have, to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
So we are asking for a date from the court.
Okay. So when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday, if we can exchange them by Tuesday.
Okay. Is it, I assume everybody's been kind of tracking this. Could everybody have what you think is the state of the evidence by Tuesday?
I don't think that's going to be hard.
And everybody should be following along with this, including the court reporter. So this should not be hard to figure out what exhibits have been entered and what haven't. And a lot of times with this many lawyers, some of them are going to have it wrong anyway.
It's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all. And if there is that might be a better way to do it. And then if there is a discrepancy and anybody believes that's inaccurate, we can take it up. So why don't I talk to and we're going to be, from now on, well, y'all all know Ms. Parker, but Ms. Parker is retiring in 1 week. I will have a new court reporter, and I know, it's the end of an era, but I'll have a new court reporter, Ms. Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts, because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there is any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when we could anticipate receiving something
I
like
think
that?
pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet or something. So I don't think it'll take long. I think I can get y'all that by next week sometime.
Thank you.
Okay. Let me write my to-do list. Okay.
All right. So my dad just got, I think his computer just shut down. I'm not sure what happened. John, if you could call him, see if you can get that figured out. Battle Girl asked, is this the DA that was in the secret meeting? Is she under investigation? I think there's been bar complaints. I'm not sure if she's actually under investigation. I don't think she's under any kind of investigation, but yes, this is the DA. And I believe the, I don't know, is this checkered at the bottom, red and black sweater or jacket is the other DA, Ms. Hilton, that was in that meeting as well, the ex parte secret meeting. My dad had some thoughts on that clip, so we'll wait till he joins back in. But I'm going to jump to kind of the big clip of the hearing, which is where the judge kind of lays down the law and lays down her room. What happened? Yeah. Your computer or what? No, I call John and just see if you can restart. Okay, so this is the clip where she kind of lays down what's the timing going to be, how long are we going to be doing court each day, those kinds of questions. So we're going to listen to her explain it, listen to things that may change, some rules that may change, some differences. Is she going to try to tighten this up a little bit? Because she said throughout the hearing that she wants to keep this tight. She wants to keep it moving. She doesn't want to waste the jury's time. She says stuff like, you guys are going to handle a lot of this stuff outside the courtroom. If we need to go 4.5 days, we're going to have a hearing here to deal with what we need to deal with. So I think that's incredibly important. I'm glad she's going to do that. I think it's the best way to handle these kinds of cases is to not waste the jury's time, not make it miserable on the jurors. And that's what it seems like she's focused on. So let's listen to her kind of explain this. Some of it's kind of funny, kind of interesting of what's been happening so far in this case.
Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're going to be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay. All right. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets.
So you're on a different Wi-Fi. Right. Everybody else, everybody's down. Oh, tell them not to get on mine. You can get on it. Yeah. If you know how to get on it. Sorry. I'm going to, okay. All right. So I guess the Wi-Fi went down and I have my own plug-in Wi-Fi at the office just for you guys. That's why we do this. So mine doesn't go down when everybody else's does. So 8:45 to 6 o'clock. So those are pretty long days. And I kind of like the idea of 4.5 days because in a trial this long with this many criminal defendants, stuff's going to come up and they're going to have to handle things Friday afternoon.
Start early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them. So that's kind of going to be my plan going forward. And it may be that we want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start.
So the plan was to start August 5th, but because of all these delays and everything that we're waiting to happen, we may have to wait another week. So that's going to be over a month that the jury is going to be out. All right, Dad, are you good?
Yeah, my internet came back.
Okay, awesome. So she just talked about a couple things just to recap, 8:45 to 6 o'clock. And when she says 8:45, she means 8:45, maybe 4.5 days a week. The jury was supposed to come back August 5th, but they may have to kick that another week. Was there anything you wanted to comment on with those? No,
I'm sure she went through the fact that she wants to use that time to get rid of as many motions as she can.
And then what about the clip before? I'm trying to remember what it was now. I can't remember when you bounced out. I can't remember. People had questions about, so how will this case work with ADA Love and ADA Hilton as witnesses? Whatever happened to the motion to recuse both prosecutors? Those kinds of questions were coming up before with that last clip. But so what are your thoughts? How do you think that's going to be handled now with the issues with the prosecutors that are still kind of open?
Okay, I'm sorry. Repeat that question. I was checking to see what the last clip was. Go ahead.
Okay, so just what do you think is going to happen now with the prosecutors? There's these motions to recuse them. They're going to be witnesses potentially to what happened in the ex parte hearing. How's that going to be affected with the rest of the trial?
Well, here there's so many things here, but there's also a very strange item missing from all this, because she's asked the lawyers, give me a list of whatever it is. The lawyer said, well, we may want to file some additional motions. I haven't heard anybody say we're going to file a motion for mistrial. Maybe I missed it. Did you hear anybody say that?
I think those are part of the motions that are still open that she would decide on. No.
Well, not now, because the grounds for the mistrial have changed since they filed them earlier, because the judge is gone now. You have the ex parte, you have all that stuff. You got the judge. She's going to have some real issues with the prosecutor being disqualified, because, again, the other judges already ruled there was nothing wrong with the ex parte. So if there's nothing wrong with that ex parte hearing, then the prosecutors didn't do anything wrong. And I think that's absurd. But again,
Yeah, I don't know though. I think that they put in all of these shenanigans, and the actions by the prosecutor, the actions by the judge are still reasons for mistrial. Nobody ruled on that mistrial motion. So I don't know if they have to refile it because did it come in after they filed the motion to recuse? They may have to refile it because of that if it can't be under Glanville. But I think some of that reasoning is still legit. And I think they can still make those arguments. I don't think the recusal motion dealt with the motion for mistrial. Actually, I'm positive it did not. Regardless of what that judge said about the prosecutor's actions, it did not rule on the motion for mistrial.
Yeah. Well, any of those open motions are still open motions. Any of those open motions are still subject to this judge ruling. And in fact, although she's careful in how she says it, she can reverse or change any of Glanville's rulings from the earlier trial too.
So she's not bound by them, but
No,
most
she's
judges
not.
defer to the prior judge's rulings.
Right. But if
But
she
maybe
thinks
not
that
when the judge has
Glanville,
been recused, right?
if she thinks he made a mistake, she can correct it, and she can go her way on it. One of the things I know that they were having trouble doing is the state identifying who they're going to call as witnesses. But now she's ordered the state not only to give a list of witnesses, but what the state thinks those witnesses are going to testify to. So that's a big deal, that the defense is going to have a list of witnesses and what they're going to testify to, because there's some 200 witnesses on their witness list. They've called 50 so far. So she wants to know how long this trial is going to go, how many more witnesses they plan on calling. And that's why she also wants an evidence list from the state saying, look, I know your evidence list had 10,000 things on it. Well, we know you're not going to put 10,000 things on it. Give me an evidence list of the stuff you're actually going to put in.
Mm-hmm.
So she's trying to narrow it down. She's trying to get into it. And she knows these are, I tell you, you're right about earlier when you noticed about that order. I don't know how much she's gotten into this yet. I'm really wondering if she's really dug into this file yet, or is that something she plans on doing this weekend?
Yeah, probably. I mean, she hasn't exactly been on the case very long. And a bunch of people are saying that a bunch of motions have been filed even since this hearing by Steele, by Weinstein, recusal of the prosecutors, probably some mistrial motion. So stuff is definitely still happening in this case and probably won't stop. And she knew that. Is the jury legally allowed to look up why Glanville is gone? No. Cody, Peter, question. Why does it take so long for the court reporter to transcribe the proceeding? I was under the impression it was getting transcribed while they were typing. Thanks. So no, they kind of do like a shorthand typing, and then or even some court reporters, you see, they put the thing over their mouth and they're talking into it and it gets transcribed later, or maybe never at all. Maybe never every word gets taken down until somebody orders it and pays for it. But once they do that, they type out every word, everybody who said it, make sure it's accurate, proofread it. And that takes a very, very long time. Francis, dumb question. Whose idea was to do all these trials together? So the state likes to do it. It saves resources and time. If it's very similar evidence, try as many as you can at once. Obviously, you're seeing there are other issues when you do that. Tamajan said, are they going to bring up the ex parte hearing to the jury? I believe the answer to that question is going to be an emphatic yes. All right, keep listening here.
Start back with the jury. I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward.
I appreciate that because I hate when they're like, oh, we can't do this because this lawyer's not here. It's like, you got 5 lawyers that work there. Or 100 lawyer law firm. Somebody can be here on time. You're not going to delay it for everybody else just because one lawyer's late. But if you're a main lawyer that's handling every on the case, you better be there on time or else they're going to keep going without you. So it does kind of cut both ways.
Okay. So I don't want to be waiting around till 9:30 to get started. 8:45. All right, so that's that. So a couple of things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have whatever drink they want to as long as you're not klutzy like me and don't spill it all over everything.
By the way, people are like, oh, obviously rolling their eyes. There are some courtrooms that don't allow you to have whatever water you want. There are some courtrooms that don't allow you to drink throughout the trial. And that is miserable when you're sitting there presenting and talking the whole time. Most will allow it. But then when you get to food, most courtrooms don't allow food at all. She's about to kind of allow it sometimes, but most of the time, that's not really how it works.
Everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that. Okay. So if we are working.
So she's going to let them eat if they work through lunch, but not snack throughout the trial, which I think is interesting. And sometimes judges will not even allow that. But I think she's doing everything she can to keep this trial moving. Do you think the jurors go back to work during this month off, or do they just have a month off? Can they lose their jobs because of a year plus jury duty?
Well, in Florida, no, you cannot you can't fire a juror because he has jury duty.
I'm sure that's how every state is.
Yes, that's the statute.
But yes, I would assume they do go back to work, and they don't just continue to take time off. Most of them are probably told their jobs they have this trial going on. So they're probably in the loop of what's going on, but whenever they can show up to work, it's probably best. Olga said, love the judge's punctuality. Don't be late.
Through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some.
What do you think about that? We know at least some of them are celebrity type rappers, things like that. What do you think about the wardrobes in the courtroom and how she's limiting that? Now, I've heard she limited it to 5 per defendant.
Well, I think she's absolutely right. You can't expect the sheriff to sit around and handle all the wardrobe and clothing. I mean, this is a trial. They are defendants. They are in jail. Yes, they can dress decently, but I don't think they have to have a full wardrobe. And I think she's right to restrict it and at least give them a warning about it.
Some of these defendants, and that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think she's not even here today. Yeah, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits. Okay. We shouldn't have 20 different outfits for anybody. So y'all need to clear out apparently the closet. So now I've done that for the deputies. They'll be more happy. Okay. Next topic. minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct
We know what that means.
court in a way that minimizes disruptions. And we'll just leave it at that for now.
So, Dad, why don't you explain this real quick? Because Snowcat said the sheriffs handle that, talking about the wardrobe. I thought the attorneys bring the defendant's clothing.
Well, they do, but they don't bring them to the defendant. They bring them to the sheriff's office. It's the sheriff's responsibility to get them from the lawyer and give them to the defendant for the defendant to change in a holding cell or whatever cell they've got right outside the courtroom when they come out. Well, they keep bringing, every day they bring them another set of clothing. Well, if the attorneys don't take back the other clothing, then it starts to build up back there in that holding cell, and they'll have, 20 outfits.
And it causes obviously a big problem if the sheriff doesn't bring them their street clothes and instead they show up in an orange jumpsuit. That's prejudicial. Can't do that in front of the jury, and it can create a huge delay in the trial. So it is a big job of the sheriffs.
There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening. And that raises some security issues with our security staff with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it. Board from here on out. So then if that's all right, well, we won't.
He said some of them are bored and that's why they're doing it. I cannot believe that would be any legitimate reason to do that in the middle of a trial. Have you ever had anybody try to do that or give that excuse?
Now, I have had defendants listening to like undercover tapes.
Well, hold on. Don't pause that, because that's exactly what he's about to say. So let's listen to this lawyer explain why he thinks some reasons for using headphones in court, and then we'll get that story from you. But as far as boredom, I've never seen a judge allow a defendant or somebody to listen to something, because there's boring parts of every trial, as anybody that's watched a trial knows.
It takes a lot of guts to even say that.
I know.
Be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay.
Sure.
Yes, sir.
I want to get a hard match, Huey. There are times where the defendant need to listen to evidence, interviews, things of that nature. And I've made that available for my clients to listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court?
So hold on, before we get to the judge's response. So you're saying you've had this happen before too, where they're actually listening to evidence or reviewing things that have to do with their case, that have to do with what's going on during trial?
Yes, I have had them do that.
Okay, and why? Why does that happen sometimes?
Well, because for instance, some witness says something, I have to be listening to the witness testifying, and I tell my client, in your tape, find where this was said so that I can use it for cross-examination. So he's acting like a helper in his own trial because his lawyer has to listen to the testimony. So I've had him find things that are in there. This lawyer is talking about the original time that the witness hears the tape, which again, she's right, shouldn't happen in the courtroom. That witness, that defendant should have heard the tape before you walk into court. But I have had times when it was necessary for them to listen to the undercover recordings or the videos in the courtroom. And she's going to kind of allude to that as she goes on here. But what he's talking about is the first time this guy ever listens to it, that makes no sense.
Which I agree under normal circumstances. But what about in a case where the state is continuously turning things over? They're going under these tapes of Copeland of what parts they're going to cut out and what parts they're not. They're in trial every day from 8:45 to 6 p.m. Like, how realistic is it to go through hours and hours and hours and hours of tapes with some of these defendants? I agree. I'm just playing devil's advocate here. Yeah. I definitely agree with what the judge said, and I agree they can't limit. The judge literally would not be allowed to limit the use that you talked about before. If the defendant is aiding in his own defense to find something for you to impeach a witness, there's no way a judge could limit that. But she could limit this and say, you got to handle that outside of court, discovery, reviewing stuff with your client, preparing for trial, things like that. Obviously, you have to do outside of court. But what do you say, like in a case like this, that stuff just keeps popping up?
Well, if the state's pulling a fast one, then you do have to do it right there on the spot. And normally, though, courts will give you a recess if they give you something that's new. Give you a recess to go review it outside the courtroom, because again, you also want your client to listen to the evidence and the testimony, because they're probably talking about a transaction where he was present. Well, he was the only one there. You weren't there. So you want him to listen to the testimony. You don't want him doing something that's totally unrelated. But if it's new evidence that just comes up, the judge will give you a continuance to go listen to it.
Otto says, does the new judge explain to the jurors that Glanville has been recused, or does she just leave it at, I will be taking over for Judge Glanville? I've actually never had this in the middle of a trial, so I don't know. My guess would be it's something like exactly what you said. I'll be taking over for Judge Glanville, and they won't ever find out the details unless Glanville becomes a witness. And even then, they'd still probably have to put 2 and 2 together to get to the actual truth of what happened. But how do you think this would go?
Well, this explanation is going to have to be an agreement between the state, the defense, and the judge. The three of them are going to have to get together and decide, okay, what are we going to tell the jury? Because if the judge does it without the defense agreement, then it's going to be an appellate issue as to, all right, oh, the judge prejudiced my client by that explanation. So she's going to get everybody together. They're going to agree on language, and they're going to make the explanation to the judge. As neutral, I'm sure, a language as you can possibly imagine.
Mm-hmm. Bodie said, why is it a security issue? I think she's mentioning when they talk about that they're listening to stuff on the computers. There's a couple different things this could be. What, you want to go?
Well, I mean, they actually could be talking to somebody outside of the courtroom with those, who knows what they're listening. You put those pods in your ear, your ear pods in, you can listen to a telephone. And you can listen to, Bluetooth conversations. You look at everybody's got a laptop there. Well, who knows what information is coming into that laptop remotely through Wi-Fi? So I can understand the security issue.
And especially with, the accusations being made, the connections to the outside world, the potential witnesses that the prosecutors are accusing them of intimidating and having some kind of effect on. So that could be some security issues as well. Tater Tot, Mr. Tragos, I assume she's talking to you. I noticed this case intrigues you. I was curious about what the case is interesting to you. What about this case is interesting to you?
Because it's so bizarre. I mean, I've never had a case that had this many issues, unique issues. I mean, these are unique issues. And so I've really enjoyed the case. I've enjoyed the defense lawyers in the case. They're tough. They're strong. They stood up to the judge, and they were successful. And I like to see that, because a lot of times the judges can intimidate lawyers. These guys weren't intimidated, and I enjoyed watching them.
Bodie said, Peter, why doesn't the prosecution just simply forward everything related to the case to the defense lawyers as they get it? That would just be far too easy in following the rules, Bodie, but they have to make the easy things difficult. And, certain things they don't want to turn over because they don't know how the defense attorneys are going to use them. They pretend like they don't have it. We saw it in the Baldwin case, how they bury stuff sometimes. It's unfortunately just become too commonplace to just not turn over all the stuff that you have. And there is some stuff that's legitimately protected, but most of the time it's just not great how they handle it. All right, let's keep listening.
A request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
Sure, and just maximizing the time that I have with my clients, since I don't have availability with him outside of court every day. So he's here, we're here. So a lot of times I'll give him an opportunity to review evidence and do that nature. So
Right.
the only reason I would ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right. I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said, everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because
She's like correcting herself multiple times to make the language a little softer than how she says it originally.
a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think y'all know what I'm talking about. What I want to know is, where are we really? I mean, I know, you know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly.
And this seems simple. It seems reasonable. State attorneys hate it. State attorneys hate it. We have to do stuff like this all the time in civil cases. You usually don't as a state attorney in a criminal case, but I mean, you think they've got to not be happy about this, don't you think? Especially when they have 150 people listed on the witness list, because whether they say it or not, they're using a little bit of that as strategy.
Well, they are. And I think in this case, they might have some fears about the safety of witnesses too. And, you know, disclosing all their witnesses and what they think the witness is going to testify to, there may be some safety concerns, but they have to be concrete. They can't be theoretical. So they may have some safety concerns. I also think they may not be positive about what some of these witnesses are going to say. Like, what would they have said about what Woody's going to say, right? That would have been great.
They don't necessarily have to be held to that. It's not like swearing to something under oath. It's just what they expect them to say, and expectations, as we all know, can go awry.
See, on Woody, you could just put a big question mark. Just put
Exactly.
his name and then this big question mark, and that would have been it.
Yeah.
Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that. So how about y'all give me a heads up on all of that?
So she's, you know, it's a little threat at the prosecutor too. You better not be bringing in stuff that's already been testified to or that's cumulative, which is great.
Okay. And if that is something that y'all could have to me by next Friday for everybody, that would be great. Let's see, what's next on my list? With regard to kind of just general scheduling, other than the week of the 29th, and then I was told, I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week? You have this week free? No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that. Okay. Say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that. Okay. But if if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk. Okay.
What do you think about that? About making sure everybody's professional and we're all members of the bar. As we know, there may be some bar complaints in this case. What do you think about that?
Well, she's putting him on notice, and she's also trying to get ahead of it. You know, she doesn't want to wait till something actually happens. She wants to give him a warning. So if something ever does happen, she can say, "Hey, I warned you. You know, at the very beginning of this case, you were warned." So they can't say that it's a big surprise to them if they get any sanctions or a fine or something like that for being unruly or unprofessional.
All right. What else do y'all think that I need to be thinking about, or do we need to be talking about, or at least?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay. All right. Mr. Weinstein?
No, Your Honor.
Okay.
There have been, this case, as you know, is enormous, and the discovery is enormous. There are certain, with Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to give a heads up. This is an example, but I don't get into this situation. I have filed a motion regarding, there was a wiretap in this case.
Okay.
And the judge, there are other issues, certain things like that. We kick the can down.
Maybe when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also, I don't know what happened to my mic all of a sudden, they could also include if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is, because yes, I absolutely want those things to have been determined before, you know, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing.
All right.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page. That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because yeah, if we need like 5 days of measure.
So that's basically her just getting an idea of what's still missing, what's still happening. So now I did want to talk about, Ashley just reminded us to talk about the plea deal situation. So at some point she basically starts saying things like, hey, if you guys want to talk about a plea deal, that sounds great too, because we're going to keep this case moving and stuff's going to be happening in this case. Or maybe I could grant a mistrial. She doesn't actually say that, but that's kind of the leverage point here where everything's kind of up in the air. Maybe it's a good time to talk about a plea deal. How do you deal with that as a prosecutor and as a defense attorney at this point in the trial?
Well, there's a nuance here. And the nuance, and you have to carefully listen to what she says about the plea deals. What she says is there cannot be any plea deals. In other words, because the trial has started, she will not accept any deal between the prosecutors and the defendants. There can be recommendations to the court if they want a plea, and the court may follow the recommendations, but the time has passed for, all right, we'll give you 2 years on the RICO case if you plead guilty. The judge is not going to sign off on that unless it's just a recommendation and the judge accepts it. So the trial starting in this courtroom, and my guess is it's the rule up there in that courthouse, that once the trial starts, no plea deals, no plea guarantees. You can plead guilty open and both sides can make a recommendation to the judge, but that's as far as it's going to go. And that's what she was talking about.
Yeah, but if we read between the lines, there's no way she's not going to take a recommendation at this point, and she's going to force them to keep going in this miserable trial that's had all of these issues. I can't imagine if a criminal defendant is willing to accept recommendation made by the state attorney in this case that she would knock it down. I do not think that that is
Well,
going to happen.
let's face it. How wonderful it'd be to pare it down a little bit to get rid of some of these defendants and some of these defense lawyers, just to pare the case down. And I think we all know that these prosecutors are not going to give away the farm. They're not going to give any, probation to any racketeering charge. So they're going to recommend some, substantial prison time. So it's not going to be an easy fix, but it is probably something. You're right. I think the odds are the judge will take the state's recommendation.
And that kind of goes to John's question, which is sometimes your eyes are bigger than your stomach. Why shouldn't they actually consider breaking this case into smaller pieces? Seems like a total mess. So one way they could break it into smaller pieces is offer some plea deals or recommendations. And if the judge agrees, then they start to pare it down. They can't just dismiss charges or get some of these guys out and try them in a different case. They just can't do that now. They've already been put in jeopardy. The jury's been sworn in. They're already going forward. They've already been subjected to the mistakes that have been made in this trial. So I really don't think that this is a situation where the prosecutors really can break it down at this point, which they know once they start the trial.
Right.
From your perspective, if you're the prosecutor, are you trying to offer anybody plea deals at this point?
If I was the prosecutor, I would have pared this case down before the trial started.
Which maybe they tried to do, right? But if they're all interconnected and you have a real RICO,
Right.
either gang or mafia or family or whatever, sometimes they do stick together and they don't start taking deals.
Which is fine. I mean, that's their choice. It's their choice to go to trial. But as a prosecutor, that's the time you do it, because you do it before you have to prepare for trial, because that's the big time consumer, is preparing for this trial. And if you're able to get rid of a couple of defendants, that's wonderful.
Which they have. They have gotten rid of some of the defendants. They have pled some of them.
Yeah, but that's the time. But once trial starts, that makes it a little bit tougher, because you're so invested. And let's face it, there's a little emotion here too. So you're so invested, that you're so emotional, that you don't want to give these guys a break.
Yeah, usually this is not the time unless you really feel like you're losing. And then if you go to them, it feels even more like you're losing. So at this point, you're already so far down the line that it's tough to really do much with. But if you guys are watching, make sure you hit the like button. If you haven't hit the like button already, please take a second to hit it. That's all we've got. That's our first impressions of the judge. Overall, Dad, I would say positive. We think that she's got a good
positive. Yeah, I'm sorry. We keep stepping
Everybody
over
thinks
each other.
I'm interrupting you, but of course, when you interrupt me, it's okay.
I interrupt him.
I was going to ask you for what your thoughts are. So go ahead.
Okay.
Give me your thoughts, and then I will summarize and do the outro.
Right. The impression of the judge is positive. If I was the defense lawyers, I'd be happy to have this judge. It seems that way. The other thing that I know it's just gut feeling. There's no real evidence of it. But I have to think, I've had this feeling that the defense lawyers think the trial is going well so far, and that I don't think they want to retry the case. I just don't get that feeling.
Yeah, I think I like her disposition. I like the way she's trying to tighten things up. I like her kind of coming in and putting her own rules on things and changing things, so everybody knows from the jump it's not going to be the same as what it was. I like all of that. I like her focus on moving it forward. Her not being as involved with all the parties and things, I think, is going to help. I really hope that she is able to move this forward and get some justice one way or the other in the case and keep this thing moving forward, because that's really the biggest deal. And it seems like that's what she wants to do. So overall positive vibes, but we'll see kind of how it goes. Thank you guys for joining us. Make sure you subscribe to the channel. Make sure you hit the like button. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.